so that the court can function in accordance with law rather than under the uncertainty of a stay order. I therefore maintain my earlier view in my note of 22nd June 2023.
What was your ground for constitution of larger bench or for staying the proceedings?
My Lord,
Your ground, what on which?
my Lord, Section 3 and 4 of the Practice and Procedure Act.
4 talks about interpretation of constitution. Whether any constitutional interpretation was required in this case?
Yes, my Lord, because they were asking for the striking down of several procedures, provisions of the NAB Amendment Act. There was on the touchstone of the Constitution. The argument being made was that it violates a number of provisions of the Constitution, the provisions relating to fundamental rights, provision relating to Islamic provisions, provisions relating to power of and authority of Parliament, provisions relating to virtually how a power is to be exercised. All of those were in question.
There's also another ground, speaking for myself,
My Lord,
where a larger bench should have heard this case, and that was the question of maintainability, because in high courts certain petitions were pending challenging the Vairis, and the judgment of the majority did refer to the Benazir Bhutto's case, PLD 1988, Supreme Court 416, which is, I believe, an 11-member bench.
my Lord,
And that is the law till today.
my Lord.
And again, this court is ignoring that law. So either that was binding and had to be followed, so any departure that was required to be made had to be heard by a larger bench.
My Lord,
So that is...
may I respectfully am very grateful for that observation. I had spent an entire day arguing Manzoor Ilahi and arguing on the basis of Benazir Bhutto and pointing out that there was a petition pending under Article 199 of the Constitution before the Islamabad High Court, and in view of the pendency of that petition and in view of these two judgments,
You see, regardless of that, Makhdoom Saab, with great respect, the larger bench judgment is binding even on this bench, because that's an 11-member bench.
yes, my Lord.
And Manzoor Ilahi's case has been reaffirmed by
my
them.
Lord. Yes,
and
my
that is the law.
Yes,
and
my
that law is again and again ignored.
Yes,
and that was also ignored in the election matter, to which the majority has made a reference.
My Lord, yes.
So that could not have been overruled, and till that is not overruled, 184(3) petitions are not maintainable if matters are pending before the high courts.
My Lord, even before the Practice and Procedure Act was enacted, that was a submission made by me before the Honorable 3-member bench of this Honorable Court, and that was my next point, which your Lordships has encapsulated far better than I could.
Arguments, we will hear you later. This is your main arguments.
My Lord, that's my second argument after the Practice and Procedure Act. The second argument,
What is the first?
my Lord, the first was that in view...
What is the first proposition?
The first proposition is that in view of the provisions of the Practice and Procedure Act 2023, the proceedings before this Honorable Court's 3-member bench had become quorum non judice, and the matter should have been referred to a committee.
So are you saying this judgment is a nullity in law?
That's what I am submitting, my Lord.
What do you say about when the Practice and Procedure Act was suspended? It was not in field.
My Lord, your Lordships knows it better than me that an order of stay operates inter partes. It operated between them, and my Lord, Mr. Justice Syed Mansoor Ali Shah refers to my submission and encapsulates this very well, that if tomorrow this Practice and Procedure Act will be upheld, the stay order will be vacated, and for that period...
So you were prescient, or was Justice Shah prescient?
My Lord, this
Or both of you?
The members of this honorable bench are always prescient.
Makhdoom Saab, speaking for myself, the petition was not maintainable in the light of the law laid down by the Benazir Bhutto's case.
My Lord, and that was my submission even prior to the 2023 Act, because the Act came in between.
चलिए ये एक proposition हो गया, अगला
Sir,
proposition
अगला
क्या है?
proposition ये है कि on the same issue, a constitution petition under Article 199 of the Constitution, being petition number 2557 of 2022, challenging the vires of the law, was pending before the Islamabad.
So I'm just thinking aloud, don't read too much into my observations. It could be that a petition comes here and someone, just to stop that, files a petition in the High Court. Okay, it could be completely mala fide. Okay, how would we know it? We can't know mala fides and bona fides, and that will happen. So should that not be a matter of case-to-case basis, just because a petition has been filed? Or, for instance, some things are time-related. Like, it's very important something happens and a party is not interested in adhering to a certain time. Let's take elections, for instance. So they file a petition, one in Balochistan, one in Sindh, etc. And someone files who's actually interested in elections in the Supreme Court. So the Supreme Court should say, hang on, let's wait those. But they will effectively get the relief what they wanted, delay. So should it be binding on us to that extent?
सब्सक्राइब करें और बेल दबाएं ताकि कोई खबर रह न जाए।